Hi, I'm Jerry Clinch with Clinch Law Firm, and today I thought we'd do a short video discussing estate planning for pets, and I guess what your options are in Nebraska. So let's go ahead and dive in. Now, I think a good starting point is just to go ahead and ask the question, what happens to your pet or pets once you pass away? Well, long story short, somebody is going to have to care for them. And without the proper planning, unfortunately, that means that your pet, legally speaking, which is considered property in Nebraska and in the United States, will have to go through probate. And that is something that, I guess, plain and simple, pets do not have time for. So doing some advanced planning can decrease the amount of stress and anxiety that your pet may experience once you happen to pass. And your passing just by itself is going to be devastating to the pet. So making the process as simple as possible is highly advisable, and I think your furry friend deserves it. So you've decided to do some estate planning for your pets. Next question is, what kind of estate planning should you do to ensure the best outcome? You've got your last will and testament on the one hand, or revocable living trust on the other hand. Which is better? Which is more appropriate when you're trying to care for an animal? In my opinion, a last will and testament is not an ideal vehicle or estate planning vehicle in order to transition your pet from your care into someone else's. Reason for that, the majority of many people have to go through probate, or their estates do once they pass away. Animals, unfortunately, and you certainly may not agree with this, but as far as the law is concerned, they are considered property. They're living, but they are considered property as far as law is concerned. So what that means is going through probate, that is a way of determining who gets your property. Or retitling assets, this and that, based on your direction if you've got a will, or state law if you did not have any kind of estate planning documentation. So what is the solution then if a will is not a great idea? Revocable living trust. And there are a number of reasons behind this, but I guess a few of the primary reasons are, first and foremost, a revocable living trust plans for life and after death. So if you happen to become incapacitated, let's say you get dementia at some point in time and you can no longer care for your dog, your cats, your bird, whatever your pet happens to be, revocable living trust can dictate who is going to take over in the event that happens. If you've got a last will and testament, that doesn't do anything for you while you were alive. Power of attorney documentation may help, but having something set up, that you've already got a caretaker who is on board, willing to do it, it's just substantially easier, in my opinion, to go with a trust than to try and do it with some other way. And the solution right here, specifically, I suppose, would be a pet trust. So you've got a revocable living trust as your estate planning vehicle. Within that document, really, that's just a contract that you're making with yourself for the most part. And once you have that revocable living trust, there can be a number of sub-trusts within it, just agreements, contracts, and one of the sub-trusts that can be included in there is a pet trust. Now, a little information on what a pet trust is. So that right there, not only does it set out who is going to take care of the animal, as well as potentially giving some alternate individuals who will take over in case the first selection isn't able or willing to do it. Additionally, raising or taking care of animals, as I'm sure you're aware, can be very expensive. So in addition to naming a caretaker, you can also set aside funds, some money, so the caretaker is able to care for your animal throughout its life. And then once the animal passes away, your pet trust can have provisions that dictate what's going to happen to any funds that remain once that situation's done. Maybe it'll go to the caretaker since they took care of the animal, or maybe it's going to go somewhere else entirely. Really, that is up to you. But a pet trust is a fantastic way to ensure that your pet will be cared for and that there are going to be continued funds in order to ensure that the caretaker will be able to afford it as well. Now, the next thing that I'd like to talk about is selecting an animal caretaker. Some of the considerations that, in my opinion, you should be thinking about when you make that decision. First and foremost, in my opinion, it has to be somebody that loves animals. You don't want to give your beloved dog to somebody that just cannot stand dogs. I mean, it's possible that they're going to do some nutty things or just not care for the animal in a way that you would like them to be cared for. Additionally, it is my opinion they should have experience caring for animals. So maybe you've got yourself a friend that just loves your dog. You comes over, plays with your dog, they have a great relationship, but has never owned a pet before. That might not be the best person to have as your animal caretaker. Reasoning behind that, once you pass away or become incapacitated and that animal caretaker is supposed to step in, if they don't have any experience, that's going to result very likely in some frustration on the animal caretaker's part and some stress and anxiety on the part of your animal, which is certainly something that you don't want to happen, as they are already in a stressful situation transitioning from your care to somebody else's. So making the process as stress-free as possible is certainly a great benefit that you can do for your animal. Additionally, your animal caretaker, you don't want them to be blindsided by their appointment. So you get dementia, you're incapacitated, you can't care for your animal, and then your friend Bob all of a sudden is told that, oh, hey, you've been appointed in your friend's estate planning documentation as an animal caretaker for their dog Spot. Well, if the caretaker has not been aware or made aware of that prior to this instance, it coming as a surprise could result in them saying, no, I'm not going to do it. That is an option. An individual that you've named as an animal caretaker does not, technically speaking, does not have to accept the appointment once the time comes around. So making sure that they know what they're getting into, that they're aware of it prior, and that they're willing to do it is an excellent idea, just to make sure there aren't any issues down the road. And then one last differentiation I would like to make. So when we're talking about trusts, there's going to be a trustee involved. That is the individual, or could be an entity as well, that handles the assets that are funded with inside the trust. You also have your animal caretaker. Now, while it is possible to have a trustee who is also your animal caretaker, that does not have to be the case. You can have somebody that is making sure that your wishes as set forth in your trust are being adhered to and providing funding to your animal caretaker. And then you've got the caretaker who just does the day-to-day care of your animal. And now we're going to go ahead and discuss some additional considerations that you should think about for your estate planning for your pets. First up, lifespan. Dogs and cats, maybe depending on the animal, you're looking at 10 to 20 years as far as lifespan for dogs or cats. Some birds and tortoises, however, can live up to 100 years. So that is absolutely something you need to keep in mind. As far as funding, if you are funding your trust with money to ensure the care of your animal, you want to make sure that there's enough to last. If your pet is going to live 80 years past your death, then that is a substantial amount of money, and the caretaker may not be willing to go through with it unless there are adequate funds to continue with the upkeep of the animal. And then there we go with cost of upkeep. So in addition to a long lifespan and making sure that you have the funds necessary to do that, certain animals are more expensive to keep up than others. Let's say, for example, you've got yourself a racing horse. That is substantially more expensive to take care of than your typical dog, cat, or bird. Even if you just happen to have yourself some some just horses, that you've got on your farm, that you ride around, just your normal farm horse, or some cows, cattle, whatever you've got. Larger animals are more expensive to keep going. They have to eat more food, insurance costs, and that's, I guess, why we're going to jump into liability next. Horses, other large animals are dangerous just for the fact that they are large. It is not a real often occurrence, but children or anybody riding a horse falls off, hurts himself pretty significantly. There is liability associated with that. Now, Nebraska does have some certain laws that deal with, equestrian or horses and things that we're not going to get into here, but just liability is another thing that has to be considered. Vicious dog is, I guess, another pretty good example. So making sure that everybody is aware of the liability associated with it, including your animal caretaker, is something that you should consider when making these kind of estate planning decisions. Well, that is all I have for today. Hope I've brought you a little peace of mind as far as what your options are for caring for your animals, and making sure that in the event that you become incapacitated or pass away before your animal does, that there is a seamless transition for who will care for them, and that they will have as little stress associated with your passing or incapacitation as possible. Please feel free to give me a call if you have any questions or would like to discuss setting up a pet trust or revocable living trust. You can reach me at 402-908-5699, or please check out my website, clinchlawfirm.com. You can make an appointment via my website and appointment scheduler, and I also have a great deal of information for you to review, as well as a good deal of education on a number of different areas of law. Thank you.